The hearing begins with clarification of the filings before the court. An answer to the motion to dismiss was filed, followed by a response from opposing counsel. Additional exhibits were submitted, though the court confirms they have not yet been reviewed. Counsel explains that earlier filings suggested the Missouri case had been dismissed, but that is inaccurate. Instead, Missouri stayed its proceedings and scheduled a case management conference for September 2, 2025. Both cases remain stayed. The judge acknowledges the update and confirms awareness of the current procedural posture, noting the importance of understanding exactly what actions remain pending in both jurisdictions. Counsel outlines the central legal issue, jurisdiction under the UCJA. The petitioner claimed Kansas as the child's home state, requiring 6 consecutive months of residency immediately before filing. Counsel argues that standard was not met. He states the child lived in Missouri within the relevant time frame and that this fact was not disclosed in the UCJA affidavit. References are made to prior testimony and filings indicating Missouri residency. The concern raised is not merely factual, but legal, as jurisdiction hinges on accurate disclosure. The judge listens carefully, noting the complexity created by overlapping filings and conflicting representations. The court agrees to take judicial notice of the Greenwood County affidavit identified by counsel. Discussion follows regarding evidentiary challenges presented by remote proceedings. Counsel explains the difficulty of presenting multiple witnesses and documents via Zoom. The judge acknowledges a preference for in-person hearings, but explains limitations involving courtroom availability, scheduling, and witness locations. The judge emphasizes an effort to accommodate parties and move the case forward quickly, particularly given visitation concerns. While open to scheduling an in-person hearing, the court reiterates that today's purpose is primarily addressing jurisdictional questions, not full evidentiary determinations. Attention turns to the protection from abuse filing. Counsel argues the child was not listed as a protected party and that alleged incidents occurred between parents, not directly involving the child. This forms part of the motion to dismiss. The judge responds by clarifying an important distinction. Even if abuse is between parents, a child witnessing domestic conflict can still be harmed. However, the judge acknowledges that case law typically requires physical harm to include a child in a final no-contact order. The court explains this factor matters, but does not automatically justify long-term restrictions without further legal findings. The discussion shifts to emergency temporary jurisdiction. Counsel argues no emergency existed because the child was not a protected party. He requests dismissal or, alternatively, temporary parenting time pending an in-person hearing. The judge raises a critical concern: how to ensure neither parent removes the child and undermines jurisdiction. Counsel responds by citing statutory provisions regarding withholding a child and stresses his client's intent to comply with court orders. He expresses concern that jurisdiction was asserted through misrepresentation. The judge probes whether emergency circumstances justified initial jurisdiction, emphasizing the need to balance child safety with procedural fairness. The respondent asserts Missouri is the home state, while the petitioner presents a Missouri court order stating Missouri is not the home state and lacks authority to issue custody determinations. However, the same order stays proceedings pending Kansas jurisdictional decision. The judge acknowledges both interpretations. Emergency jurisdiction is then revisited. The petitioner argues the mother's arrest left the child abandoned, requiring immediate court action. Counsel counters that a no-contact order prevented communication. The judge ultimately finds emergency temporary jurisdiction existed because the child was physically present in Kansas during the incident, allowing the court to issue initial protective orders.